bullet point written. So if I saw in initial few minutes, if I am the first speaker and I saw that there are very few questions coming from the judges, so I gauged that it's a cold bench, and therefore I almost argued everything written in my structure, right? So that I'm able to cover that 15-minute or 12-minute time which has been allotted to me and do not finish it quite early. Now, there would be a situation where you'll feel hot benches, and mark you, I have seen hot benches marking better. They grill you a lot, but they mark you also better because they test you on how good you can think in terms of when pressure is there, right? So, when there is a hot bench, I would see, and of course, when there is a hot bench, you'll face the issue of losing time, as rightly pointed by Garima. So if there is a hot bench and I see a lot of questions coming up, I'll try and remove some part of my structure and I'll rush away with the second issue probably. So let's say in my first argument, I have three things to show or three sub arguments to prove my argument. If there's a hot bench, I'll only convince them with the strongest of my argument and not move with the other two. And I'll directly move to the second issue, right? That is what I did while facing the hot bench and the cold bench. Also, if you're going second, look, all of these issues you'll face when you are going as the first speaker in the round. Now, if you're going as a second speaker, you'll already be knowing that whether it's a hot bench or cold bench. So by that time, you'll be in a position to prepare your mind that how I have to go about with my speech. Should I speak slow? Should I run away with my speech? And what the bench is preferring, right? Also, one thing I have, of course, that's my personal opinion. Arguing in front of hot bench or arguing in front of a judge who asks you a lot of questions is very satisfying because it shows, at least that is from both as a counsel perspective and as a law student perspective when I did mooting. It shows that the judge is interesting, he's listening to you, he's understanding your argument, to what extent he's understanding your argument. So never fear hot benches. They are very, very good and it helps you improving your skills. Also, I've seen, I think this goes to your last question that how to respond to judges when there are questions being asked. I've seen there is abrupt silent at times when some question is thrown to the participant and he's thinking or he's probably sorting out what to answer. Now, just to fill up that gap, you can probably use certain sentences that, for example, the council understands the concern of the tribunal, or it's a very valid question raised by the court, or thank you for the question, or something of that sort of fillers you can use to fill that abrupt gap. Also, if a lot of time it happens, so there's a three-member tribunal or a two-judge bench sitting, and they both ask you questions and the participant would only answer one of them. Never ever do that. You should write the question if you see that there are a couple of questions being asked and then accordingly answer both of them, right? Also, while you are arguing, keep a close eye to eye contact on the judges because there would be a situation that you are arguing something and from the facial expression of the judge you'll be able to gauge that there is something is missing or he is not understanding something, and on that point you can probably say I sense there is some question or concern from the side of the court or the tribunal, and you can engage with the tribunal, right? Always allow the judge to complete the question. That is very, very important. Never ever just come in between. Just allow the question to be completed. Also, if you do international moots, uh, I have seen people from civil law background, they prefer more of factual arguments as compared to common law background people. So if some question is asked, because at least in Viz it happened that you are required to exchange your cards. Right now, when you exchange your cards, you see the name of the judge and the nationality. So you get to know that he is from common law or civil law. And accordingly, you can frame your answer. Because civil law people would not really look much into the authorities or the judgments, they would straight away get into the facts. So it's always better if you are it's like you know the bench. If you know the bench, you are good to go. Uh, and of course, final point. As a judge, I have experienced this. If you don't know something, it's always good to admit and move on. Don't just beat the bush around. Just admit the council is unaware and move with your argument. Don't just say that. Just don't bush around the bush. That's all. Thank you.
Thank you, sir. Garima ma'am, would you like to add something to this?
I think I definitely agree with Alok, especially about admitting that you don't know and then you move around, because a lot of times what we fear while admitting that we don't know is that that's what the judge will remember and then they will mark us down. But we sometimes forget that it's okay, they might remember that, but then they will also remember the harsh time that you've been through if you don't know the answer and you're not admitting it and you're wasting the time of the court. So it's better to admit and move on. I think it's very tricky to, okay, and coming back to the original question, how to tackle a hot bench versus a cold bench. I think it's very, very, very tricky. I think this is something that probably I don't have an answer to. It is something that one has to, what should I say? One has to just explore as they move forward in their oral rounds. But yeah, the basics that one should definitely stick to is stick to a straightforward answer. If you don't know, move on. Don't beat around the bush, and try learn some tact. And I think practice your arguments enough to be able to at least be thorough with your knowledge of law and facts. A lot of times, I've noticed that um, it's what preempts the hot bench to be asked to become even hotter is because they realize that the council doesn't even remember the facts. Like they're desperately waiting for the council to point them to the right fact that will really help his case. But because they know that he has the potential, so they keep giving him the opportunity, but he doesn't get to it, and then it just becomes like a circular thing of question and answering on the same point. So I think the most important point, if you're thorough with your preparation, tackling questions I don't think is a problem then. So being thorough is the key to be able to tackle all kinds of benches. That's all from my side. Thank you.
Thank you, ma'am. Jayant sir, what you will say that sometimes students face cold bench when they are mooting. Like they are not able to understand that what is expected from them, right,
So
in
I
the
think
moot court.
then you have to be like an actor. You have to stick to your script. If you are facing a non-participative bench, keep going on. At least maintain your eye contact. And I'll tell you the reason behind this. Reason is sometimes when you are inviting judges, they have had a very busy day. They're all working professionals. Some of them might not even have had the time to be very honest to read the mood problems. They just enter and they are like let's go with the flow. Let's see how our other co judges are. I'm not saying it's the right approach. Judges who are getting there at least have the basic courtesy to go through the proposition and be prepared. Because the participants who are there, have done so much of hard work. They have put in there with some expectations from you. So don't be entirely cold. But then again, I think it's a matter of luck. Which co-judge do you get and what team do you get? So it's a big gamble for everybody, for the participating judges and for the teams. So I think luck plays a major role. So for example, let's say if I was to share a bench tomorrow with Garima ma'am and Alok sir, now that I've had a fair idea of how they are, I'll be the one who will be keeping quiet because I know that they are good with their questions, they know their preparations, and they may be firing at the participants. But then my role comes, as someone I would say a little more experience in the profession, that if they're training their guns at a person to calm them down, to just quietly, peep over to them or a book cover and say, look, let's cool it down here. Let that young man or woman, who are arguing the matter, give them a chance. It's also a matter of, I think, basic courtesy. These are life lessons, I think, more than anything else. No more proposition says be aggressive with the judge. No more propositions gives the judge a right to be aggressive with the candidate. So it's a matter of common courtesy, which we have to extend to each other as human beings, and I think as fellow lawyers, I would say. But how to handle them, I think as Alok and Garima ma'am have already pointed out, maintain eye contact if you are facing a cold bench. You already have a narrative in place. I would say people while participating, getting ready for a moot, the other co-speakers and the researcher drill each other, practice before a mirror, have mock drills amongst yourself. That always helps. I used to do that at my time. Even my team, I remember we had this one moot in GLC Bombay. It had turned international. It was the first year. and my team members were very they were scared. So and I said, look, let's go through the proposition. It was a very tricky problem, and then I ensured that at least they knew, even if a question came from the judge which was not prepared, or if it was a cold bench, they would be ready to answer. And as luck would have it, in the semi-final, we got a really hot bench, first to say. I would not say rude, but they were very poignant with their questions. And because we are already prepared, with any type of questions coming our way, so they could answer most of us, and that sailed us through the finals. So I think practice amongst yourself. Cold bench, keep on with your narrative, be polite, be courteous. Just take the judges through your memos if they think they're not participating. So at least you know that you are engaging them. Then they become your audience. But if you have a hot bench, then you are their audience. Because then they are doing all the drama and you are at the receiving end.
So what should be considered lucky, getting a hot bench or getting a cold bench?
It's destiny, Madhur. As I said, it's a gamble. It's a jigsaw puzzle. You can only have your fingers crossed and hope for the best. That you don't get rude people. I would say it's not about cold or hot benches. If you have decent judges who can ask you the right questions, who are drilling you at the right point of law, that's all that matters. You can't ask a counsel to shut up. You can't ask a counsel to don't know your stuff. You can't be aggressive just because you have been, let's say, having a bad day, or you had a bad case in court, or you got a scolding from your partner in the firm. I don't know. These things, don't bode well in the long run. Organizers always keep a keen eye on the judges, and if you're misbehaving with the participants, I can tell you from my experience in the past 12, 13 years of judging moots, you will not be recalled to the moot to judge again.
Thank you, sir. My next question is to Palak ma'am. Ma'am, while framing the memorial, how you keep the points flexible, that what kind of judges are coming and what kind of questions they are putting to, and you will answer that according to your memorial.
I think your question is how to argue your case, right? The same set
So
of
how
facts with a different
flex-
bench.
how flexible you keep your points in the memorial, so that different sets of bench when you face to answer them.
Um, what I believe is that what I have personally done also is that every issue or every moot proposition has a limited set of points from each side, which a party has to establish. So you pick out the most important point of those particular points and then lay that out first. So the chronology should be on the basis of importance that particular point has in order to establish the entire case that goes around through issues and as well as through sub issues. And for example, if it's a hot bench and you have, so that bench might not even give you a chance to prove your most important point. For example, in my personal experience, one of the judges did not even listen to one entire issue from my side. He said that you do not have the locus standi, so please move on. And he did not even uh, give me the opportunity to present my case. And there have been cases in cold benches where they give you an entire opportunity for a good 20, 12 to 15 minutes to just speak, and they do not ask questions. So you have to I don't think there's a particular answer to this, but you just have to read the bench to see. That's all, Madhur. Thank you.
Thank you so much. So the question is coming for the panel from the audience side. That is, what are the qualities that a speaker should must possess? Alok sir, can you want to answer this?
Okay, so what qualities a speaker should possess? It depends on which mood you are doing, but I'll talk about the common ones. You should be clear in whatever you are saying. You should understand the question, what the judge is asking. You should lay down the structure well, because a lot of judges have the habit of noting down your structure. So just see what the judge, be with the bench as it is said. Also, don't run with your speeches or your structure. Be slow and use the voice modulation at the right time. Now, again, it would depend upon which case, which mood you are doing. criminal law moods, you might use a lot of voice modulation depending upon what you are arguing on. In arbitration mood, you would be very informal, just like you're talking to a judge. So it would depend upon what mood you are doing, right? So understanding the requirements of a particular mood and fitting yourself according to those requirements is an important quality of a speaker. Uh, I think these are the things which are coming to my mind right now. I'll wait for other panelists to add. Thank you.
Thank you, sir. Jen, sir, what would you like to add?
I think what I expect in a speaker is, to be smart. Simple as that. If you have the basic street smartness in you, look, every team has studied the law, the moot proposition. The idea is what is your USP? What is that extra bling that you bring to the table to the moot competition? It can be your demeanor, it can be your style of arguments, it can be the way you draw an analogy to a particular moot proposition. So I think that matters a lot. I'll give you an example. I did this moot a long time ago, and unlike the hot and the cold judges, I had a very cold speaker. I think it was a mock team which was created by the law school. And on one side, we unfortunately got the mock team, and they were not prepared at all. So this lady lawyer who got up, to argue the lady counsel, and she was not prepared. And it was, I think, a 3-page of memorial, if I'm not wrong. And there was a 3 pages were just we are looking at each other, and I'm like, let's give them time. And we just asked them, have you read the problem? They're like, we have read the problem, and we were all the people with me were even senior to me in that moot court. So we just said, why don't you apply yourself and say something? And in 5 minutes, I think the lady started crying on her own. It was a different experience, being a judge. But I've had, some instances. Even I think in the lockdown, I have just 2 to 3, I think, online moot courts, and I've seen some really good speakers, who are really on the point, who knew the proposition in and out. I ventured out a little bit out of the moot problem to, test their general knowledge and other things, and they were spot on. So I think that's what you require as a judge, to test them, not just with the moot proposition, but the other, as I said previously, on general knowledge, on their awareness in general sense of other laws that may be playing a part. Are they keeping themselves up to date with the recent judgments of the Supreme Court or of the relevant High Court? So all these things, I think, really matter a lot if you're a speaker. And you just have, as I said, you have to be street smart. That's the thumb rule for any orator.
Thank you, sir. Garima ma'am, would you like to say something on this?
I think I'll just quickly add to whatever has already been said. I think one important aspect for a speaker is to learn how to think spontaneously, because no matter how much you practice, how many practice sessions you attend, how many questions you anticipate, I think it is always possible that there will be a new question out there that will be thrown at you during the oral rounds. So you have to, as a speaker, have to learn to be spontaneous in your thinking, and I think that can come with being thorough with the issues that revolve around the moot proposition. That is one, and the other thing is, I think, something a lot of us struggle with, and naturally so, is getting a little mini panic attack when a question is thrown at us during the oral rounds. I think that's something we should definitely learn to avoid, and overcoming that will, in my opinion, come with practice. So yeah, that's all. I mean, of course, this is other than the basics that you should be a fluent speaker, you should have certain voice modulation techniques, and it should not appear that you've just mucked up something and you just want to spill everything out without really engaging with the bench. So yeah, that's all.
Thank you, ma'am. Sir, one repetitive question that is coming from the audience side is whether online moots are as fruitful as offline moots. Jen, so this question has been asked from you specifically.
I think, look, they are, especially in times when we can't step out. I think, as someone who has done moots and as somebody who is not judging moots, it's not very difficult. Look, the actual human connection is always a miss. I personally was going to court and going to moot court competition. There sometimes are a few technical glitches here and there, but I think they can be forgiven. They can be pardoned. It's the zeal which counts, And now at least in a computer screen, for example, now we are having this panel discussion. I can look at people, I can put questions to them. I would say some conveniences there, because students are still working as hard on the proposition. They're still researching as well as they were doing before. I don't think there's too much of a change in online offline. Just the thing is, when you're online, you're meeting other people in person. The interaction is at a more human level, I would say. Virtually, I think we have to just find a way to live with it. That's it.
Thank you, sir. The next question for the panel is do we really require any search engine like SCC Online and Manu Patra is there? So do we really require any search engine to do good in the moot court?
Well, I'll just quickly address it. I think it depends on the subject of the moot court competition. Like, I've majorly participated in moot court competitions that relate to WTO law, and for that, we really don't require any search engine because all WTO judgments are freely available on the website. In fact, SEC Online, I don't think SEC Online even captures WTO judgments, WTO panel and appellate body reports. So, for someone who's doing a WTO moot, you really don't require any search engine. So it really depends on the subject matter being captured. No.
Thank you, ma'am. Alok, so would you like to answer this question?
Madhur, I am really sorry. Can you repeat the question? I just
Yes,
disconnect.
sir. For sure.
Yeah.
So question was, do the researcher really require SCC Online and Manu Patra or all those online search engine that provides them case informations?
Oh, okay. For national moods, I would say yes, because SCC has really great head notes. I love head notes of SCC. Also, if you want to judge, if you want to look for high court or even lower court cases, Manu Patra becomes a good search engine there. So, if you really know how to use Boolean search and Boolean operators, these search engines help you a lot. Even in international modes, so if you are doing I did mostly arbitration modes. For arbitration modes, Clover on arbitration is a really good database. But for Indian judgments, I would recommend SCC and Manu Patra being the best in the market. And researchers should start before first he or she should understand the concepts which are involved in the problem. But then the next step should be to look in the SCC or the Manu Patra on the judgments revolving around the concept. Once you have read the concept from the books and other places. So I think the search engines are very important, but you should know how to use. Not many people know them. In fact, Westlaw International is also there, which not many people know, but it has great database. So one should know how to use Boolean operators, and then you're good to go.
Thank you, sir. Jen, sir, I think you have some point to add on.
No, look, as Garima ma'am already said, it depends from mood to mood, and Alok also said, but depending if it's the international mood, trade mood. I remember participating in one of the moods which had some ICSID problem. It has international treaties and conventions. So research, I think, is the backbone of any moot court. Without researching, it's like going to the war without a gun in your hand. You won't be winning the war. You will absolutely, come browbeaten from the judges. So you have to keep the research as the foremost point and ensure that while you are researching, you are covering all the bases. Without research, you can't make a memo. Without a memo, you can't be doing your issues, and without the issues and without a memo, you can't be arguing. So yes, I think the answer lies in the question itself. That research is an absolute must. You can't skip it.
Thank you, sir. So as we have very limited time, I have like one or two more questions, and after that we will end the session. So the question for the panel is that how a judge decides that which team should be marked, should be given a preference in marking than other team.
I think it's a matter of bench to bench. If every judge is a different bent of mind. Sometimes I think the bench discusses among themselves, and but by and large, I have seen that people individually mark them. Because everybody has a different preference. I may think some person was good. My brother or sister judges may think differently. That marking independence is a matter of your own intellect and your own thought process of how you perceive a particular speaker to be. But if a team is by and large good and if they're performing well, they sail through. People can't and won't be marking a bad mooter over a good mooter.
Thank you, sir. Garima ma'am, would you like to add on this?
I'll just quickly say that actually, in a lot of Moot Court competitions, if not all, they already reveal the marking criteria and the rules of the competition. So there are set criteria for marking the speakers. So I think the skill is in developing, perfecting each and every skill, each and every criteria that is going to be marked upon. And so even if of course there lies a lot of subjectivity depending from judge to judge, but those are the basic criteria that judges use, and they are basically, these criteria revolve around knowledge of law, knowledge of facts, application of law to facts, demeanor, ability to answer questions, these kind of things. It's usually given in the rules of the competition. Yeah. Thank you.
Thank you, ma'am. Alok, sir, would you like to add on something to this?
Well, it depends, as rightly said by Jayant, so it depends on bench to bench. However, I would say that mostly when there is a close neck to neck competition, it happens the benches or the judges discuss among themselves. That's mostly what happens. I'm not sure that at every place, because whenever I got confused while that who should win, I generally consult my fellow judge. But having said so, your question is how you decide or how the judges decide which team is winning and which team is losing, right? Okay, so I strictly speaking on, as rightly said by Garima, there is a scoring sheet which is provided. At least I stick to that scoring sheet, and I strictly mark on whatever categories are given under the scoring sheet. So if there is something which is not there in the scoring sheet, I will not mark bad to the participant on that criteria. So for any person who wants to know that what or how the judges mark, is to just see the scoring sheet, and you can easily get, as Garima said, you'll get it on the moot rules. If they are not there on the moot rules, any judge would easily tell that what are the common factors which are marked or which are looked upon by the judges. But I think response to question is very, very important criteria which I have felt, and also how far the student or the participant appreciate the concern of the tribunal. Lot of time it happens they don't answer the question of the judges, and they move uh, with their speeches and structure. This is not a very good thing to do. You should at least recognize or appreciate the question made by the judges, and possibly then you can. But then these are the common factors which we see while marking. That's all.
Thank you, sir. Palak ma'am, the question is for you. Can you kindly tell briefly that a lot of students comes to Moot from like different colleges. They all come well researched. Then what are the special things like you do to add on or to showcase that you are better than them, like in presenting the Moot or in arguments?
What I personally believe that sets you apart is the mannerism with which you present your arguments. And I personally believe that sometimes people or teams get aggressive in pushing towards a point which they firmly believe in. So I think that should be avoided. And at all times during the course of the moot, the speaker should maintain their calm and composure with which they answer their question. I think that actually makes the judge with an impression that the person is confident and the person is clear, And apart from that, I think deep research really helps. Like from if you read from varied articles apart from just the main case laws which everybody is going to read, so that helps you in getting a deeper understanding of the problem. So
Thank you.
that's all. Thank you, Madhur.
Jen sir, can you throw some light on like any specific presentation trick for the mooters during presenting his moot?
I think just be crisp, to the point. As I already said, no new tricks. Be thorough, be smart, and be smartly dressed also. I think that's also important. Your appearance has to go with your arguments, because everything counts. It's a mark of presentation. Your language should be spot on. It should not be fumbling. If anybody has a problem of stammering or other things, please practice on your speech. It's equally important that any speech impairment should not come in the way of your marking or your merit. I think that is also very important. If there is a problem like that, the judges should be told in advance so that they can allot you some extra time. Then I think be courteous to your oppositions also. It's very important. You're not in a war, where you have to belittle, or when you are doing your rebuttals or sir rebuttals, just sometimes people the ego takes over the pride, and I think that's very difficult. Be proud of who you are, but at the same time respect the other person. I think it's very very important because judges, evaluate you not just on your mood proposition and also on your overall conduct.
Thank you, sir. Alok, so would you like to add on something like some special technique that can give an edge to the another team that is mooting?
Okay, so first of all, I'll make a small point with regard to the last question regarding the judging criteria and everything. I always give a caveat to all the teams, whoever I have judged while giving the feedback. The caveat is that every judge or every arbitrator is different, and that's what the reality is. Every person is different, so every feedback would differ. Some judges would like you complete all your arguments in the limited time. Some judges would want that whatever you argue you convince the bench, right? So never take any feedback, or for that matter this session, to be the end of mooting. There has to be subjectivity to it, and that makes you, or that prepares you for actual life. That is what actually happens. It depends on the judge. Therefore we wait for the right judge to come, or maybe we wait for the roster to change. So therefore that was one thing. The feedbacks are subjective. Coming to this present question, uh, one tip which I should give is, you should live the mood. When I say live the mood, I mean, I remember when I participated in my first arbitration moot, lot of people said that it's very important that because there would be international judges there, so you have to be very clear in whatever you are speaking, because there is a chance that their first language is not English. They are from EU or some place where they have some other native language, right? Therefore, what I did personally, I adapted slow speaking in my way of life. Now, how I have done in other moods before that arbitration mood, uh, the way the fillers, the courtesy that is required for a speaker should come in your daily life. Now, if you start living that thing, it would not be a much. And also, another thing is you should visualize. The power of visualization is immense. For all the public speaking uh, platform, or whenever you have to prepare for public speaking, it's often advised that you visualize that there is a big audience sitting. Similarly, the speakers should do that. There is a judge sitting, he would ask you questions. The more you visualize, the more comfortable you'll become when you go and argue the moot. So I think that's one tip. Otherwise there are so many tips, but that's the tip I would want to give.
Thank you, sir. Garima ma'am, would you like to add something to it?
I think I would just, I, I definitely agree with Alok when he says that you live the mood. And I think that goes not just for speaking, but also in terms of, like, I remember me with my teammates, we used to practically for those 6 months, because we've majorly done international moods, and international moods take have a bit of a longer timeline than national moots in some cases. So for those 6 months that we are preparing for our memorials, and even later on for our orals, the moot problem used to be running at the back of our heads the entire time. Like I remember seeing dreams in my sleep about the moot proposition. So that was the level of engagement that our brains had with the moot proposition. And I think it's only when you really engage yourself in it that you can, because the more you think, the more you progress with your research. So I think with presentation, I agree with everything that has already been said. It's very subjective. Everyone has their own style. You have to go with the flow of the bench. You have to understand what the judges are asking for, what are they appreciating, what are they not appreciating, and you have to be sort of adaptive to that. And there's no one good way or bad way, I think, of arguing in front of the bench.
Thank you, ma'am. Jen, sir, sometimes we see that students comes up with a flow chart or something like that. So being a judge in the moot court, how you see this thing? Like, do you give
Uh,
an edge to the presentation to that particular team who is coming up with a flow chart or something like that?
I haven't had the chance to see any flowchart so far in any of the moods that I have judged, Madhur. But I think I would definitely appreciate the effort. But at the same time, if you get a hot bench, they may take it adverse. They may just ask the council, "Do you think we are fools? We don't understand the problem. Why we don't have flowchart for us?" Depends on just to judge. You get a crazy person. They just take you out for a good round and then dump you right there. But if you have a cold bench, they're like, "Oh, thank you so much for the flowchart," because they never had the time to study the problem. So as I said previously, it depends from person to person, and bench varies from the personalities which are deciding the bench.
Thank you, sir. Alok, sir, would you like to say something in brief?
Well, flowchart in terms of oral presentation, I haven't seen, but in memorials, I have seen. While explaining the arguments, some participants use flowchart, and it really helps because at times it happens. So let's say there is a question of biasness of the arbitrator or the challenge of the arbitrator. Then you draw that how it is related through a flowchart. It gives you a better perspective. That is what I have come across a couple of flowcharts while there was this issue that whether the arbitrator has relationship or whether the arbitrator uh, matches the impartiality or independence requirement under the act. So a couple of teams explained through flowchart that how he is related and how he is partial. So I think it helps in better understanding, but you should not overdo it as in uh, you should be clear. If you're adapting that flowchart, it should be very clear, and the judge should understand. That's it.
Thank you, sir. Garima, ma'am, would you like to add something to it?
I think generally speaking, usually these extra things like flowcharts or other visual representations during the arguments I would say are more appreciated. I think in an international mood rather than more so. I mean, and not so much in a national mood. I would suggest, and I think with the it really depends from mood to mood. I think, like for example, in the ELSA Moot Court competition on WTO law, which is now the John H. Jackson mood, they really appreciate visual representations or these creative ways of giving arguments. And because ultimately the idea is to make the bench understand or to convey a point clearly and precisely. So whatever helps you float your boat, I think it's welcome.
Thank you, ma'am. So we are moving towards the end of the session, and the last question is, how the mooters should take the defeats in the moot. Jen, sir, can you kindly come up with?
I think, Madhur, there are no winners or loser. It's just an experience, as my co-panelist already said, you have to live the mood. It's a experience you have to live. And just to end the session, I normally do to take a share or two. So I'll just say one share for the session today. It goes like this: कि सुबह होती है, शाम होती है, जिंदगी यूं ही तमाम होती है. So mood are a part and parcel of life. You have to live the mood. It's not the first mood or the last mood or the first thing in your life. You'll have so many other experiences. So just live them, enjoy them. I think it's very important to enjoy the whole process of learning and unlearning. You learn about yourself. You learn about the people who are judging you. You learn about your opposition. You learn about the organizers, you learn about a new place that you have visited. There are so many facets, just to a simple moot. So I think just live it, love it, and don't take anything to heart. Always have a positive stride, even if you don't, succeed in a particular moot. I know it's disheartening when, especially, you have put in so much of preparation, but as I said, luck plays a major factor. If you really get a difficult judge or difficult bench, or a team which is better than you, let's just say, not your fault. You did, but give it the best shot that you've got. Is all I will say, and then move on. Just you have to keep moving on in life.
Alok sir, would you like to add something?
Okay, I don't know whether it would sound more of a Gita Gyan, but still I'll try and make it uh, how I did it. I never understood that why people consider anything or any moot experience to be a defeat. It might be in terms of you have not won the moot, but I don't think you can ever make a statement that I lost that moot. So why I said so, I remember when I did my first moot, I was really happy with the fact that I am representing my college and I'm going to this place and I'll represent my college. And that was complete in itself. Now, I was just happy arguing and representing the college. The result really did not matter for me. I went and I was adjudged as the semi finalist. But as I said, I was happy to the fact that I represented the college. Also, you don't understand, but you learn a whole subject area. Now, while preparing for any mood, I never only restricted myself to the problem, because I've heard from a lot of people that Indian judges a lot of time don't read the problem. They'll only ask questions on which they know or on their experience, right? So I used to read all the ancillary laws and or whatever was there in my speech. I used to read everything in and around. So I did so because it firstly it helped me to learn a new law in a better way. So let's say if you say to someone that I have done an IPR moot or I have done an arbitration moot, that person or you should be in a position to know that IPR or you know that arbitration law, right? So with that perception or with that intention, you should do any moot. Also, so I'll just tell you what whenever any person or any participant loses any mood, he should take a paper and write down things what he has won. He has learned a new law. You have developed few good relations, probably made a new family in terms of your mood partners. You have made a great network in terms of interacting with judges, your fellow participants. You have represented your college. You have for which a lot of people are fighting. I've seen it takes a lot to clear intras nowadays. There are 200 people participating and only 80 would make to the panel. So you have represented your college. You have seen some great speaker and some great memorials. And your defeat would give you time to analyze and think where you went wrong, which the winner would never get that opportunity. I've also won a moot, and I remember I forgot even to see where I went wrong. And whenever I lost in the semi-final, I always thought, what could I have done better? So you are having that great option, right? And with a final quote, I'll end that if you learn from a loss, you have never lost. So that's how I see defeat in any mood. Thank you.
Thank you, sir. Garima ma'am, would you like to say something on this?
I think some very, very great points put forward by Mr. Jayant and Alok. It's true. That's the essence of the moot court, of a moot court, of participating in a moot court competition. That it's winning or losing, or the perception of winning or losing is in fact in your hands. You can perceive that you have lost if you really if the result of the competition is the only thing that you concentrate on, or you can perceive that you have emerged as a winner by counting the value it has added to you, as a lawyer, as a person, as a student, as any professional. So yeah, it's really, I mean, we have to remember that participation in local competitions is not just about your merit or your ability, but it's a lot about luck also. The teams you face, the judges you face, the the overall setup of the competition and everything. So it's really not in your hands to be winning or losing beyond a point. So it's just it's in my opinion it will be immature to think to feel defeated or to feel demotivated if you don't win, like as an outcome of the competition, but to concentrate on everything that you've learned. And it's really a really enriching experience, and definitely it's worth it even if you don't end up winning the competition as such. Yeah, that's
Thank
all.
you.
That's all from my side.
Thank you, ma'am. Palak, could you like to say something like how you take defeats and you are still in law school and how you take defeats like pressure of, I think college is not pressure exactly, but expectation of college is there. Uh, how you take that?
I would agree that there is a college pressure that exists when you're in law school and you're representing your university, so that increases the stakes. And but I completely agree with all the panelists that whatever they have said, because honestly, mooting is a life experience, and you get to learn a lot, and not just in the area of law, but as Alok sir erstwhile said, that you make a lot of friends or some lifetime connections. You learn how to you visit a lot of places, as Jayant sir said. So there is a lot of more there is a lot of other things that are involved than just what is going on in the mood proposition. And I personally believe that one should always enjoy the entire process rather than thinking about whether they would win or lose it. You should enjoy the entire process, and just live the mood, as all the panelists said. So that's all. Thank you.
With this question, we have reached towards the end of the program. I would like to thank you all for accepting our invitation, and I would request Jayant sir, being the senior panelist, to say something as closing remarks or any advice to the law students.
I think, Madhur, I feel very old, but thank you. I must thank my co-panelists for bearing with me, and all the audience for sparing their time to come and listen to us. And Palak madam, being a student herself in law school, I wish you all the luck and all the best. Just as a parting note, as I said, I normally do my share of shari, and for moot courts and for life in general, there is last share that I would address to the August gathering here. There's a share which says Surkhru meaning successful. It's a Urdu word meaning successful. तो सुरखरू होता है इंसान ठोकरे खाने के बाद सुरखरू सक्सेसफुल है जैसे कि सुरखरू होता है इंसान ठोकरे खाने के बाद रंग लाती है हिना पत्थर से पिस जाने के बाद हिना is what you use in Hindi. So
Yeah.
like in life in moot court you require a lot of grinding and then grinding will make you successful which will give you life lessons. So that is my takeaway from today's session, and I hope I learned a lot from my co-panelists, and I hope I have something in turn to teach with my experiences to the audience and to my panelists. Thank you for having me.
Thank you, sir. Thank you for accepting the
Thank you,
invitation
sir.
and being here.
Thank you, Madhur. Thank you, Lexi.
Thank you, ma'am.
It was a great session. I think we all really enjoyed it, and I particularly enjoyed it because I got to revisit, my mooting days as a student, and I think it's a golden period being in law school. That's the only time you get to participate in moots. Like now, even if we want to, we can't participate in moot court competitions. We can at max be a panelist. We can never get the feeling of that adrenaline rush when we approach the bench, and it's really worth living, worth experience.
Thank you, ma'am.
Okay, thank you, Aon. Bye.
Thank you, ma'am.
Thank you, Madhur, for this opportunity. I never thought somebody would call me to really talk on mooting skills and all. As a first year or second year student, I never.
It's just your kind.
No, I'm being very truthful, and the people who are listening should pay attention to this fact that I was as a first or second year student, I hardly spoke, or I was hardly able to spoke one or two lines in English. Uh, Now, at least I worked lot lot on my speaking skills, and participating on in any moot was a luxury to me. uh, and Now I am taking this workshop, or you invited me for this session. I'm really glad, and it was a great learning for me, sitting with Jain sir and the other panelists. Thank you so much, Madhur. Great
Thank
time,
you.
and keep be safe and take care.
Thank you, sir.
Thank you, Madhur, for giving me this opportunity. I honestly never thought that I would get this opportunity in my second year of law school. So, thank you so much of
Thank
considering
you.
me worthy.
Thank you. Uh, so we are ending the session.
Right. Thank you, Madhu. I'll take your leave. Thank you so much.
Yeah.
Thank you, sir.
Bye.
Okay, Alokji. Okay, madam.
Bye, sir.
Okay, thank you. At the end of the session, Lex Peeps would like to thank all the media partners and all the audience who has been a part of this discussion. Thanks to you all. Due to you all, it has been possible. Thank you.